regarding, as far as the 2 hours.
Yes.
With this guide, which is so helpful, that's very simple, it simplifies everything. So
Yeah.
and it addresses different sections and chapters are really important points. Would you recommend that versus going through every paragraph, have it in front of them to refer to or read it first just to become familiar so that when you do go through it, all you're hitting on is the high points because they've already read the beginning of this.
If they did.
If you can.
If they did, that's the thing. You'll give it to them. Chances are they won't have gone through the whole thing.
When do you give it to them? In other words, if you just show them, 3 houses for whatever they say, I want that one, I want to do it now, there's really no pre-time, I mean, it's just.
I recommend in the buyer's class that you give that to them at your first meeting because it shows your value. You're
Awesome.
giving them the
Okay.
mold book, you're giving them the lead paint book, you're showing your value. No other agent is doing that. So when we get together, I'm going to give you all the forms that you're going to look at because you're going to be very emotional when it comes time to do an offer. You're going to be very excited,
Yeah.
and all this stuff I'm going to be throwing at you. It's like we have a 20-page agreement of sale and all these other things. I want you to be prepared.
Once you
So I want to
start
talk about it.
as far as your relationship, as far as once you've got it in writing that you're going to represent them, then you give them.
Absolutely. Right.
Perfect. Awesome.
Absolutely. Right away. You show your value with that. Okay, I want to do the mortgage contingency, and then we're going to jump to the inspection, okay, because that's the other thing that we have to talk about changing. So the last thing I want to talk about for the mortgage here is about property repairs. So, Mr. Buyer, if you're a mortgage lender, and sometimes they do, their appraiser goes out and looks at the property, even though you had a home inspection, the appraiser may write down that they recommend some repairs be made to the property. Now, in the old days, it used to be always with FHA and VA they required repairs. Now, even with conventional, they require repairs to a property. If your mortgage lender requires repairs to be made to the property, even though we negotiated not to do them with the home inspection, and they want them done, we have to give the repairs and show them to the seller. This is what people don't do. They don't follow the contract, but this is what it says. Give the list of repairs to the seller. The seller then starts a time frame. Okay? So it says here, within 5 days of receiving a copy of the requirements, the seller will notify the buyer. So the buyer has to give them to the seller. The seller then will have 5 days, and you can't see it all on here, of receiving the copy of the requirements to tell the buyer whether or not they will make the repairs at their expense, at the seller's expense. Do most sellers do that? No, they're not going to make repairs at their expense, right? So then they're not going to do it. What do we have? Number one, if seller makes the repairs, so the seller really wants, you have a really good seller and they want to keep the buyer in the contract. The seller says, fine, I'm going to make the repairs. The buyer must accept the property. That's what that says. They say, the buyer says, well, I don't want the property because I didn't think there was that big of a problem and now I don't want it. Well, guess what? You really can't get out because we already pre-agreed that if the seller makes the repair, so you tell them. Say, so if the seller agrees to make the repairs, if they see a roof problem and the seller agrees to make it, you're agreeing to buy the property. You're going to have any problem with that? And at that point, they're going to say, no, I'm not going to have any problem. So they won't say, you didn't tell me that. Okay, so you have to tell them here. If the seller will not make the repairs, or if the seller fails to respond, you see it's in bold. If seller fails to respond within the stated time, I thought that was important. Buyer will, within 5 days, you can change that to 3, okay, or whatever you want, notify the buyer's choice. The buyer will make the repairs with the permission to access the property. Then you have to do the pre-settlement possession addendum, which allows the buyer access to the property, okay? Or terminate the agreement, get their money back. If the buyer fails to respond, bold, within the time frame or fails to terminate the agreement by written notice, buyer will accept the property. This is the thing that agents forget, that you have to stay in the time frames. Because not only is a buyer at risk for losing money, they're at risk for being forced to buy a house that they didn't necessarily want with repairs that were needed if they don't stay with the time frames. So back and forth, back and forth. I have so many agents say, well, I sent an email, oh, this is my thing. I sent an email to the agent. I knew we were out of time, and I sent them an email at 9:30 last night to extend the time frame, and I never heard back from them. And I said, guess what? Your buyer just accepted the property with no repairs. But I sent an email requesting an extension. It doesn't matter. It's mutual agreement in writing to change any date. You as an agent just telling somebody that you need an extension on a mortgage commitment will not fly. Especially in the home inspection addendum with repairs. Well, they were really nice to me before, and I thought we had a really good relationship, and they were being real friendly to me, and now she's saying, my buyer just bought a property. I say, guess what? They did. They did. I can't stress how important the dates and the time frames are, and mutually agreed upon changes. Okay? Any questions? All right, let's move to, oh wait, they're inserting a new line here. FHA must always appraise for the sale price, so it doesn't matter what you don't put loan to values in on FHA mortgages, they always, and VA must always appraise for the sale price. Okay? Let's go to a new paragraph. Oh, okay, don't forget this one. Change in buyer's financial status. I would have liked this whole paragraph to be bold, but they only gave me the last line. This was a new paragraph we added last time. To explain to the buyer how they can lose their money. Thanks, Mike, and I have to go.
Thank you.
They can lose, in the event of a change, so you say, Mr. Buyer, you cannot take out any loans, go to Best Buy, take their credit card, go to Kohl's, get an extra 10% off, okay? You cannot do any of that from this point forward. You cannot buy a car. You cannot take out a student loan for your child. You cannot do anything that will affect your credit score, which means any kind of application for money anywhere. In addition to changing your job. Do you know how many buyers we've had who changed jobs in the middle of the mortgage process? Because it was a better job, and they're going to make more money.
Kathy, I think First American prints out.
They do, the 10 Commandments, yes.
10 Commandments.
Make sure you give them the 10 Commandments. They are in the document library, the 10 Commandments of the mortgage process. Buyer understands that applying for and or incurring an additional financial obligation that affects the buyer's ability to purchase could jeopardize them losing their money. They cannot do that. So now they've added this new language, which you're seeing for the first time here. Let me bring it down. Change in seller's financial status. I don't know how I feel about this clause. This is a new clause. Okay? In the event of a change in seller's financial status affecting seller's ability to convey title to the property on or before the settlement, seller shall promptly notify buyer in writing. A change in financial status can include, not limited to, seller filing bankruptcy, foreclosure lawsuit against the property, a monetary judgment that's been entered against the seller, notice of public sale, seller learning that the sale price of the property is no longer sufficient to satisfy all the liens and encumbrances against the property. In the event of death of the seller, the representative of the estate or a surviving seller shall immediately notify buyer. Failure of seller to promptly notify buyer in accordance with this paragraph shall be default by seller. This is new. That's nice, but it doesn't say, so what happens then? They're notifying you, now what? It's all going to depend on what it is. Okay, so they must notify you. So what they're trying to avoid is, you know, the buyer's going all along and they're putting out the money for the inspections and all, and then boom, the seller gets notice of whatever that's happening that is now going to have penalties and interest and inhibit them from being able to sell the property. They must immediately notify that. So what happens if a seller's in default?
Well, buyer gets his money back.
Buyer gets his money back. Buyer doesn't get a house.
Buyer buys a house.
And what happens if they spent money on appraisals and all kinds
Can the
of
buyer get money back for appraisals?
Buyer can sue for it.
Robin's
things? But
asking.
this-
Can the buyer sue for specific performance?
I would think so.
They can sue for specific performance.
Is the seller?
Would they want to probably sue for specific
Not if
performance?
they.
So the only thing they're trying to do, in my opinion, by doing this is to like shorten the pain and the suffering. Okay, like you must let us know right away. So when you are on the seller side, you're gonna have this agreement of sale, the new one that's gonna come out in a couple months, and you're gonna say, you know what, if you have any change whatsoever, you gotta notify us, because we gotta put the brakes on. You're obligated to know, you can't just say, oh, well, I thought, okay?
Is the seller responsible for the commission then, since we brought in a well-read,
Can
well-made
you get blood
buyer?
from a stone? If they're getting all these notices, they probably don't have the money. But
So-
would they legally be obligated because you brought them a buyer? Absolutely. Who's gonna sue a seller for commission? Do they have it? Can they get another judgment against them? You
Is this
could.
gonna be on the contract from the seller side, did you say?
It's gonna be on the new agreement of sale when it comes out.
But how does the seller know about that?
They'll know when they get as soon as they're notified. We're saying any change that they're notified about, they must disclose. Okay, Will?
This morning, just so you know, I attended Suburban West class on bankruptcy. And it was very interesting that the whole thing with bankruptcy is that once anybody files for bankruptcy, and just filing for bankruptcy, that property now becomes basically property of the trustee. So the seller is basically out of the loop here, and that's who you're dealing with. Because once you go to either file or in bankruptcy, now you have a third governmental party handling that transaction. And we even talked about commissions. You have to go and basically fight for your commission.
Mm-hmm.
So I actually, it was just coincidental that
Mm-hmm.
we did that this morning and seeing this on here.
They may not even know yet.
And the thing is, you hope that your seller's telling you the truth. You hope the seller's saying, hey, I filed bankruptcy. You just
Sellers
don't know.
always tell the truth, just like buyers do, right?
I'm saying, hopefully they're telling you the truth.
Hopefully.
Yeah.
Okay, let's move to your inspection paragraph. Tell me what you have it called there. I don't know which paragraph you are because I have a couple extra ones in here. So take me to inspections because they have a new name for it.
Inspection contingency or waiver contingencies?
Okay, so it used to be
No,
called
inspections. Right below
just
inspection.
inspections.
Right.
So now you're going to have a new title called
Buyer's due diligence.
Buyer's Due Diligence / Inspections. Okay? That's all right. What does due diligence, who can explain to me what due diligence means? It's like, these are the two things that we just always start. Time is of the essence and due diligence. I don't know what you're talking about. What's due diligence mean?
That you make every effort, that the buyer makes every effort possible and available to them to protect their own interests.
What's required?
Just think of do. Due diligence. They must make every effort, you're right, to do what they're supposed to do, diligently. So do it diligently is kind of, the way that I always remember it. So do everything you're supposed to do diligently. Do it when you're supposed to and get it done in the time frame. So, not a lot of changes here, but this is all pretty similar. What you need to do in the home inspection clause is say, now we're going to choose the inspections that you are either going to elect to happen or you're going to waive them. So they're either going to sign on one side of the page or the other. Anything in red they have added. So what did they add here? Under home, property, inspections, environmental hazards, mold. In the committee, we went around and around and around a million times whether to put mold separate like lead paint is. But lead paint is separate because that is a law governed by the EPA. That lead paint and all of that language and that addendum must be separate from the agreement of sale. Mold we put in and combined it here with environmental hazard. The one thing about inspections that you have to know is whatever time frame you have in there, you have that time frame to get as many of the inspections done as possible. That being said, if mold is going to be a problem, if you know someone has children with asthma or whatever, and mold is going to be an issue, then you want to be sure to have your initial inspections done quickly so that if there are any additional inspections, you have time to get them done in the time frame that you do. Whatever you choose, 10 days, 15 days. You have that whole time frame to get as many done as possible. So get the traditional standard ones done sooner so that if you have to add any others, you don't have to wait for the seller to accept them. Any questions there? All right, so you're going to go down, waived, elected, waive, elected. So whether or not they do a mold, that's included in the general inspection. They added in the word, buyer may conduct inspection of the property structural components, roof, exterior windows, and exterior doors, exterior building material. What are they talking about there?
Stucco.
What's the big issue? How many, I've gone by like 3 houses lately, 3 big houses where they've been there a while, the whole outside is torn off, that they're getting stucco redone. Houses that are like 6, 7 years old to when the problems start to occur. So stucco, building materials, big issue. Big issue. So any building materials of the exterior are covered here. Okay, so you don't have to write, if it's a property with stucco, you don't have to write a separate stucco inspection. It's included in this one, you just have to be sure you have it ordered. Okay? So we have that added in here. What else did they add? They put C notices regarding property environmental inspections, but I thought they're moving them into. They're moving as many, I guess they couldn't move them all into the agreement. So wood infestation, don't call it a termite inspection because there are more than termites that can affect wood. Okay? So when you meet with a buyer the first time, you're going to find out and tell them what the customary inspections are, and then you see if they want to do them. And they're going to say to you, well, what do you recommend? Right? Do they say that? You're going to, and what are you going to reply? When somebody says to you, what do you recommend for inspections, what are you going to say?
You can't recommend.
Those are my big ones.
Do you recommend certain things? Paul, what do you say?
I go through all of them and I let them make the call.
Right. Okay. Don't ever recommend for somebody to not have an inspection. So you say, I'm going to go through each one. I'm going to tell you what they cover. It has to be your decision. Never tell somebody that they don't need an inspection. Well, most of my buyers only get these. You probably don't need the water test with the full water quality. Okay? Don't ever do that. These are inspections. I can tell you what's customary, but I recommend that you find out everything you can about a house, knowing that everything that you do is going to cost you money. You decide where you want to spend your money. I can't decide where to spend your money. Don't ever recommend. Okay? Everything is a better recommendation. So deeds, restrictions, water service, radon, you're going to go through each one. You're going to explain very briefly what it is. Property insurance. Okay? That means if they elect property insurance and they want to be sure the property is insurable, there actually are some properties that are not insurable because the previous owner made too many claims against the property. So you want to be sure that they get a quote from your insurance lender, hopefully your in-house insurance lender, ahead of time. Property boundaries, lead-based paint is all in bold because it has to be. Okay, here's where they put the, they put some new language in here. So at the bottom of all of these individual, you have additional inspections if you need to add them in there. Okay, the inspections. This is a little area that people forget is here. Okay, especially if you're on the seller side, you forget to even look at it. If you're on the buyer side, you forget to even put anything in here. The inspections elected above do not apply to the following existing conditions and/or items. Now, if you have a buyer that is buying a property that needs a lot of work, and the reason that they are giving this low offer is because they know that it needs new windows, new roof, okay, and the deck is falling apart, then you should, as a good buyer's agent, exclude those items from the home inspection. They can be done, they can be inspected, but you're not going to negotiate based on them, so you're not what we call double dipping the seller. You can't go to the seller. If you are a good seller's agent and you agree, your seller agrees to a low offer, you say, you know what, they're going to take this offer, but they already can see that the windows need to be replaced and the roof is a problem. We already disclosed all that. We're going to ask that those be excluded from the inspection contingency. We can have them done, but we're not going to negotiate on them. That's what this line is for. And so many people forget to use it. Is that clear?
Yeah.
You understand what that is? Okay? So keep your hat on there, seller's agent especially. So you're not going to come back to me and ask me, for money to replace all the windows when we just took your offer 20,000 less because of all that you want it done. Notices regarding property and environment inspections. Poor or improper installation of exterior building materials may result in moisture penetrating the surface of a structure where it may cause mold and damage to the building. So these are all notices, okay? Asbestos is linked, environmental hazards, wetlands, mold. These are notices to a buyer so that they help you to inform them of what the dangers could be and advising them to get the items inspected. Every inspection is going to cost them money, right? Let's spend some time here now on the time frames, because this is what gets confusing. Then I'm going to go to the what's recommended by the committee, the recommendations. I'm going to need your input on that. And let's first look at how it is today, for any offers today. Inspection contingency. The contingency period is blank days. You can change it from when? Execution of the agreement. For each inspection elected, except for the following. What kind of inspections would you want to put here? So say you have 15 days. What kind of inspections may take longer than 15 days? Other than sewer. What? Pool?
In-ground pool.
In-ground pool, maybe it's a snowstorm, you can't get it inspected, something, okay? A water test that maybe they don't just want the bacteria water test for a well, maybe they want the comprehensive one, you need more time. That's when you would use this, okay, to make these dates be different and longer. So, except as noted in paragraph 14C, if the result of any inspection elected is unsatisfactory to the buyer within the stated contingency period, okay, accepts the property, terminates the agreement, or presents the report with the corrective proposal and/or credits desired by the buyer. This is where agents get in trouble. Not only do all the inspections have to be done, but the report and the acceptance all have to be done within those 15 days. There's not like we're going to give the report to the seller and then we'll tell you what we want, we're going to give it. That's not what this means. So for those of you who are new, you need to understand, in that contingency period, everything's got to get done. Chances are you're going to make it longer than 15. I've had some people put a little thing there and say 15 business days. Not many sellers are going to take that. That's a long time. You can get it done in 15 days, but if you have a big farmhouse and you've got to do all these other kind of extra tests, pay attention to how much time you need. Okay? So now you're going to accept, you're going to terminate, you're going to present the written proposal, you're going to use the reply to inspection form. The proposal may, but is not required to include the names of the properly licensed or qualified professionals to perform, provisions for payment, so who's going to pay it. This is something that people forget, retest. Who's going to pay for the retest? You have to put that in a proposal. Don't just say something's going to be done, then who's going to pay for the radon is going to be remediated, but then who's going to pay for the retest? Some radon remediation companies include the retest in the system. You need to specify that in your proposal. That'll have to be a whole other class for another day, how to write a reply to inspection proposal. We'll have a sample inspection, then we'll write a proposal. No later than blank days, 5 if not specified, from the receipt of the proposal is new. I'm reading this. What does yours say? Then the end of the contingency period, right? Okay, so right now let's live the way you have it, because that's the one you have to keep with. So what it says now that's not working, which is why they want to change it. So you had 15 days. Then even if the seller got the reports on day 10, the seller does not have to reply, as life is now, until 5 days after the 15 days. That's how it's written. Most agents don't understand that. Co-op agents, they don't get that. Okay? So, I want to come to your paper because I don't want to look at my paper.
Kathy, can I
Yes,
just
yes.
ask you,
Yes, ma'am.
Does day one start the day after the execution date, or is it the?
That's a good question. When is day one?
Day after execution.
Day one is always the
From
day
the
after. And I advise you that when you figure out those dates, not only do you give it to your client, who else do you give them to?
Operating agent.
The other agent. There's a form in in PAR, in zip forms, that will list all the dates. Give it to everybody. Okay, so everybody has them. Paul?
How about the check? I always thought sign, seal, and deliver when you start the next day.
What do you mean?
In other words, you have an agreement of sale, it's been executed, but you don't have a check yet,
Yes?
and that's part of the agreement of sale. So what I always use is sign, sealed, and delivered. When I have the check, the next day is when the date starts, to my mind. No?
No.
But
Remember I said that in the very, very beginning? Airport's over here. That's why I never sent my kids to Epiphany School. Change them for school. I can't go to school with the jets flying over top. The check has nothing to do with the execution date of the agreement. It only claims a buyer in default if it's not in when you said it was supposed to be there. Okay? So that's why I said in the beginning, if you can't get that check because you're doing things with DocuSign, then let the check be part of the second deposit, or let it be delivered, check to be delivered within 24 hours of execution. Change it. You don't, it's not, the execution date is the day one after everybody signs. It has nothing to do with the check. So be careful with that. Good question. Good clarifying question. All right, so what's going to happen here? You're going to present the reports with the corrections that they want. Okay, include the things, all right, and then no later than 5 days from the end of the contingency period, seller will get back to the buyer. You can read what this is. That the seller will either satisfy all the terms, not satisfy all the terms, and then it says if the seller agrees to satisfy all the terms, boom, the buyer accepts the property. Okay, that's where people get in trouble. Well, I don't want the property anymore. Guess what? The seller disagreed. They just agreed to accept everything. You bought a house.
Congratulations.
Congratulations, you bought a house. But I didn't want the house. I don't want them to do it their way. I wanted to do it with my contractor, and I don't want them to do it. Whatever you write in that proposal is very, very, very important. It has to be exactly what the buyer will accept. You say, we're going to form together a list of what we want them to do. If they agree to everything, you will have bought a house. And the buyer will say, well, if they agree to everything. So it's up to you as an agent to be sure you write it very carefully. Who chooses the inspector? The inspector is licensed and insured. There are words that you have to add into that reply to inspection. If they do it all, fine, they bought a house. Buyer said, okay. Within blank days, 2 days of receipt of the written notification that the seller will not satisfy all of the terms, or if the seller fails to choose either option in writing, then the buyer accepts, terminates, or we were very nice, we added 3 there, try to work it out. Within those 2 days, you have 2 days to work it out. If you don't work it out within 2 days, Mr. Buyer, if we don't work it out within those 2 days, we have to then act. In those 2 days, we have to, if we can't get the seller to give us what we want, we must terminate, or you will have to move forward. So it's kind of like you're being forced to move forward. It's very important that you as the agent keep those dates, knowing what happened. When did they respond? Now we only have 2 days to work it out or terminate. By midnight, terminate in writing. Buyer signature, fax it, scan it, email it. If you don't have a scanner, take a picture of the paper with their phone, text it to the person, something that you can prove that you did. Okay? So let me talk about what they would like to change. Okay? This is one thing they have here. Okay, this is one proposal. So no later than 5 days, where it said the seller has to respond from the end of the contingency period. One of the proposals is from the receipt of the proposal, seller will inform the buyer of what they want to do. So whatever date that the seller gets it, they have 5 days to respond. That's not too bad, right? It's not confusing. So what else did they add down here? If buyer and seller do not reach a written agreement during the specified contingency period and buyer does not terminate this agreement by written notice within the time, buyer will accept the property and agree to the release of this agreement. Ongoing negotiations do not automatically extend the contingency period. So just because you're still talking about it, you still have that time frame that you must accept or terminate. So they kind of reworded this a little bit and they wanted it to be very clear. That's one way they want to change this. Hold on one second, because I want to give you the other 4 things that they're going to say here. Oops. I thought I had this email pulled up. Are you finding this helpful?
Yes.
Okay, good. All right, I'm going to try to. I like this very last thing because he knows me so well. Here's what he said. Look what he says here. Just remember that I don't want to know what you think, but what your agents think. Hank is an attorney who handles the handled the forms committee. We're very good friends, and he's just being funny. Now, so what he is trying to make this bigger for you. Okay, these are the proposals they want to do. One of the choices that they're talking about is there's one single set due diligence style time frame by which everything has to be done. For example, inspections, negotiations, and resolution all must be done in 15 days, and it's up to the parties to leave enough time for everyone to get in their say. I believe that's what was shot down. Okay, so that was one thing. You just have, a lot of states have that. You have 15 days to do everything, try and work it out. If you can't, goodbye. There's no back and forth dates and all that. Just try and work it out in 15 days. So that was one proposal they had. The second one says that back and forth time periods like we have now are all set in stone. For example, 15 days to get inspections and turn over the reports. Then after 15 days are over, count 5 days for a seller response. That's what you just saw, right? And then after those 5 days, count 2 days for a buyer response. No matter when the reports are given, the days don't start counting until the end of the prior time period. I don't know what that means, so somebody help me with that.
Well, I think, I was gonna question whether or not, do you have to have the seller, sign off that he received the proposal? Like, if you give it early,
Right.
and they don't sign something that says it, then they could contest that they received it. But this, by setting it in stone, 15 days, 5 and 2, kind of didn't really matter when he got it. Or
Well,
when.
you always want to be able to prove when you gave it to them, and by giving it to the agent, it's like giving it to the seller. So there is language in the contract that says anything delivered to an agent is like giving it to a seller.
Well, does the agent sign off on it?
The agent, no one signs to accept an inspection. The only document that you ever sign to receive something is homeowner association documents. There's a form for that. So you don't have technically a receipt. So that's why it's important that you have enclosed, please find a copy of the inspection report. Always copy yourself on any email communications that you send to another agent. Always copy yourself so you have that proof. And in this day and age, I would send them a text message. I just sent you a copy of the home inspection report with our corrective proposal. Cover your bases. Then I would go into Facebook and I would message them privately and say, I just sent you a copy of the inspection. Just want to be sure you got it. Please confirm. Okay, because they're probably on Facebook. But just get a confirmation that they got it so that you have your dates and you know. Wayne.
It looks like what they're trying to address here is the question of, that you said that there is a lot of confusion, because we've seen that with competing or cooperating agents.
Yep.
Where right now, I think that, like you explained, it's 15 days, and then you start counting the 5 days, and then you start counting the 2 days. So technically, you don't have to respond until the end of all those days.
Until the end of the contingency
Right.
period. What they're definitely trying to change is get rid of that contingency period, because that has caused more confusion than anything else in the market.
But it
Okay.
looks like one of the proposals is you count the next level of response or the next action based on, let's say there's 15 days allowed. If they turn it into you in 7 days, shouldn't have to wait that extra 8 days before you start counting the next period. You can start counting that 5-day response period after you receive it.
I think that's what they're saying
That's
here
the
in
third.
number 2, right?
Yes. Yes.
I
Okay?
think it's the third one.
The only problem that I have with this one is that if they do it, they could, what if you get the radon inspection on this day, and you get the wood infestation report on this day, and you get the home inspection on this day? Which one are you responding for?
And that's the third option.
So let's go to the third. Back and forth time periods that all float depending on performance. For example, 15 days to get the inspections and turn over the reports. Then after the last report, regardless of when it's delivered, start counting 5 days for a seller response. Then after that response, 2 days for the buyer response.
Very much.
So no matter when you get, as long as everything happens within 15 days, and as soon as you get something, but everything must be done within a time frame.
But then you're having to keep track of many more dates, because you might have gotten the radon in.
You
and-
got the radon, yeah. The better thing is to collect them all.
Seems
Get it
so
all at
far
one
into-
time.
That seems so far into the agreement, as far as so many days in though, I mean, that's a lot.
That's why some sellers are like, give me the report now. I know you don't have to give it to me until, like, you're not supposed to give the report without the proposal. But a lot of sellers push the agent and say, give me the report now so we can look at it and see what we might want to do. The radon's going to be a little thing, you know, don't worry about it. But, oh geez.
At least it wasn't any more personal.
You better hurry up.
I don't have to worry about that.
I'm not telling anybody on the tape what just happened.
So,
Thank you.
it's Kathy, you don't have to respond until 5 days after you receive the report. It's not when they sign it, right, when they date it.
When who signs?
Say that the buyer, I'm the seller,
Your seller.
the buyer signs it the 29th, I don't receive it until the 30th.
You're getting the corrected proposal and the report delivered to you.
On the
Right.
30th, that's the day, it's not the
Right.
day they officially sign it.
No.
It's when
No, they
you
don't
receive-
sign anything. Yeah, they're not signing anything. So
Well,
they're getting-
initially,
Delivered.
yeah, when it's delivered to us, that,
You
we
know,
have
you don't
5
have to
days
sign.
from that.
Yeah, you don't have to sign anything, there's no form to
Right.
sign when you get it. But, so if you had to write this clause, knowing everything that you just learned and that you're thinking about, what would be the perfect scenario? Don't even think about what they proposed to us, what would be the perfect scenario? What would you think would be the easiest thing to recommend to a seller or a buyer, like when you're trying to explain it with inspection? Susan?
Well, I would think that you have to take into consideration how quickly you can get someone in to do the inspection, and how simple is the inspection, like you said, if there's different things going on there, if they offer everything.
You know what, John? You can actually turn this off because we're just getting suggestions. Thank you all for being here.